This is the recorded lecture for Chapter 4, Federal and State Courts. This chapter teaches the nuts and bolts of our judicial system, how it is structured, and how it operates generally. At the end of this lecture, my objective is that each of you will understand and explain and be able to explain the structure of the federal court system and the jurisdiction at each level. Understand and explain the structure of a typical state court system and the jurisdiction at each level. Understand and explain each step of a typical criminal prosecution, knowing the order and sequence of those steps and the constitutional protections that affect it. Know the role that attorneys, judges, and juries play in the context of a criminal case, and also how they get those jobs. And last, be able to describe and give examples of the following concepts: original jurisdiction, appellate jurisdiction, limited jurisdiction, personal jurisdiction, subject matter jurisdiction, geographical jurisdiction, hierarchical jurisdiction, diversity of citizenship, writ of certiorari, booking, arraignment, grand jury indictment, preliminary hearing, plea, and voir dire. Pay close attention to these objectives. When you are studying for exams in this course, these objectives are a good check to see whether you'll be prepared for the exam. We're starting out with a concept that applies to all courts, state and federal. Before any court can take action on a case, it must have jurisdiction. I imagine that many of you have a common sense understanding of what jurisdiction means. What I'm about to teach you, though, is what it means in the legal sense. Jurisdiction is defined as the power of a court to hear and decide a case. It comes in 4 types, and you probably just heard me list these types when I was going over the concepts. These 4 types are geographic, personal, subject matter, and hierarchical. Each of these 4 types must exist simultaneously, or the court has no power to take action over a case or over its parties. The first and most obvious type of jurisdiction is geographic jurisdiction, which, as the name suggests, is jurisdiction over an area or location. Most states have their geographic jurisdiction lines drawn along political boundaries, like county borders, or for higher courts, state borders. That makes it pretty easy to figure out. For example, the state of South Carolina, as you see pictured in this image, has 16 circuits. And you can see how these circuits are separated by county lines, and they include more than one county. Greenwood County is in the 8th Judicial Circuit. So the courts in the 8th Judicial Circuit can hear cases involving events or property that occur or are located within the 8th Circuit. Pretty obvious, right? The federal court is similar, and I'll get to it in a minute. Because those courts are part of the federal government, though, their geographic jurisdiction may cross state borders in some situations, and I'll show you what I mean in a bit. Geographic jurisdiction, as I said earlier, has to do with the location of events and property that are involved in a case. There's a related concept known as venue. Venue and geographic jurisdiction are not the same thing. Geographic jurisdiction pertains to the power of a court to hear a case. Venue is more about the location of the courthouse and where exactly a case should be filed. So geographic jurisdiction and venue are related. Venue is just a little more narrow and is more a matter of convenience. Sometimes venue is a factor in the selection of a jury, though, so it is important. A party can file a motion for a change of venue. He or she can ask the court to send the case to another venue, in order to have access to a pool of potential jurors who haven't already formed an opinion about the case. But regardless of the venue, the court must have geographic jurisdiction over the parties, over the subject or the event involved in the case or the property involved in the case. They have to be within those borders. The next type of jurisdiction is personal jurisdiction, which, as its name suggests, is jurisdiction over a person. For a court to have power to control what a person does or doesn't do, that person must either reside or take some action within the geographic jurisdiction of the court. So even if you're not a resident of Greenwood, South Carolina, if you commit a crime in Greenwood, you are still subject to the personal judicial circuit courts. There is a lot of nuance to the determination of whether a court has personal jurisdiction. There's actually one of those judicial review tests that applies to the determination of personal jurisdiction. It's called the minimum contacts test. But that's a little bit beyond the scope of this course, so I'm not going to go into it. Just know that even though it seems pretty simple, right, residency or activity within the geographic jurisdiction of a court, that's pretty simple, and that's all you really need to know. But be aware that it is a little bit more complicated than that. It's just something that you would learn in a law school course, not a college course. The third type of jurisdiction is subject matter jurisdiction. And again, as the name suggests, it pertains to the court's jurisdiction of the subject or substance of the case. Subject matter jurisdiction can be general, which is where a court may have power over all subjects, or limited, where only certain types of cases can be heard. Common examples of courts that have limited subject matter jurisdiction are like criminal courts versus civil courts, probate courts that would hear matters involving wills and estates, family courts for adoption or divorce, juvenile courts, small claims courts where the amount of controversy is very small. You would go to a court that has jurisdiction over the specific subject matter involved in your case. Those would be courts of limited jurisdiction, and you might hear it also referred to as specific jurisdiction. The last type of jurisdiction is hierarchical. This type of jurisdiction pertains to the order or sequence of a case as it progresses through the judicial system. Cases always originate in the lowest court that has subject matter jurisdiction over the substance of the case. And that court would have what's known as original jurisdiction. It is where the case starts, where the complaint is filed, where the evidence or witness testimony is first presented, where a judge or jury decides the outcome. So wherever a case originates will be in the court that has original jurisdiction. So that's the jurisdiction to take a case at its origin. There's always a party who is aggrieved, right? There's always a loser in a case. And whoever that person is who's aggrieved by the outcome in some way, they usually have a right to appeal to a higher court. And so the case is going to progress up the hierarchy to a court that has appellate jurisdiction. Appellate courts have a larger geographical jurisdiction, often covering the entire state in which they're located. They will not take evidence or hear witness testimony. There is no jury, only a panel of judges. This is because appellate courts only address legal issues, not factual ones. There is no trial. There is no determination of facts. When a case is in the original court, the court of original jurisdiction, that court will collect or form a record of all the evidence and witness testimony. The record is then certified complete and can be sent to an appellate court if the case is appealed. But once it's certified and complete, No new evidence can be introduced, and there will be no determination of facts beyond that point. Again, there is no jury. There is no trier of fact in an appellate court. There's only a panel of judges who will review the lower court's record and apply the law to that record and determine whether there was any legal error. The parties often file written briefs arguing about whether there was a legal error, and sometimes the attorneys for those parties will deliver oral argument before the judge panel on those legal issues. But the panel of judges will decide, and their decision is then binding upon all the courts of original jurisdiction beneath them. The appellate courts are where common law is made, changed, or affirmed. The appellate courts make precedent, if you recall that term from the last chapter we covered. Appellate decisions are distributed in case reporters and on legal databases. They are a matter of public record, and you can find them online. Some appellate courts only hear certain types of appeals. So to combine concepts for a minute, some appellate courts have limited appellate jurisdiction. For example, in Alabama, where I practice law, there is a court of civil appeals and a court of criminal appeals. Both courts would hear appeals of right. This means that any party who lost in the court of original jurisdiction had a right to an appeal. But if it was a civil case, their appeal went to the Court of Civil Appeals, and if it was a criminal defendant, the appeal would go to the Court of Criminal Appeals. Last, some appellate courts have the power to refuse to hear an appeal. A party may not have a right to appeal to that court, but could file a petition called a petition for writ of certiorari, asking the court to hear their appeal. This often happens when a case has already been appealed once, and the losing party on appeal wants to have an even higher court hear his or her argument of some legal error in the decision. Yet once a case gets to the court of last resort, meaning there is no higher court, the decision on appeal will stand and be binding upon all courts of original jurisdiction in that state. Note that I just said in that state. Decisions of courts of last resort are binding only within that state, not upon courts of other states. Now that said, decisions of one state's Supreme Court can be very persuasive upon courts of other states, but they are never binding. This slide is an effort to show the structure of a typical state court system. It includes the hierarchical jurisdiction, geographic jurisdiction, and subject matter jurisdiction at each level. If you notice the arrow here, I'm showing you how the precedent set by a court will bind the courts at lower hierarchical levels. The decisions of a court can only bind courts in a lower hierarchical level, but decisions of the court of last resort will bind all courts in that state. Keep in mind that this is a very generic display. Every state has its own unique organization. One of your assignments for this chapter is to research the court system of your home state. And with that assignment, you'll see in greater detail how jurisdiction is determined, and it can get kind of complicated. But this slide is kind of a review of the things that I went over just a minute ago, so I'm not going to go through it again, but you can study from it. Now we're going to look at the federal court system. Just like state courts, federal courts must have all four types of jurisdictions simultaneously in order to have the power to hear and decide a case. The jurisdiction of the federal courts begins with our U.S. Constitution. Recall that the federal judicial system is one of three branches of our federal government, and its power to act is controlled by Article 3 of the Constitution. Here is Section 1 on the slide, and it reads, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. By this language, and this is the original language, written back in 1789, by this language, the founders of our nation established a court system as a third co-equal branch of our national government, and they only gave it one Supreme Court. That's all that was created, one Supreme Court. Article 3 then gives Congress power to create inferior courts, and I don't mean that qualitatively, I just mean lower courts that may have different organization. So Article 3 then is creating the power or setting the power of the judicial branch, but it's also here giving some power to the legislative branch. It's giving power to Congress to enact some legislation that creates inferior courts and organizes them. And right after the Constitution was ratified, our first Congress got busy doing just that. They passed several pieces of legislation. They were called the Judiciary Act, and they created inferior courts. So at first, back in the late 1700s, there was only the one constitutionally created Supreme Court, and then Congress enacted legislation that created 3 federal circuits and 13 district courts, 13 being one for each of the 13 original colonies. Well, as you would probably assume, the federal court system grew just as the nation grew by population and geography. And this is what we have now. We still have the one Supreme Court. So you see here, this is the current makeup of our U.S. Supreme Court. There are 9 seats on this court and have been for several decades. John Roberts is the Chief Justice, which means he has certain administrative roles in addition to his job as a justice. Then there is Samuel Alito, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. They have little red circles around them because, of course, they were appointed to the bench by a Republican president. The last 3 are Stephen Breyer, Elena Kagan, and Sonia Sotomayor, and each of them were nominated by a Democratic president. That's why they have little blue circles around them. And there's a pretty good reason for the designation between red and blue. As you might guess, those top 6 justices tend to be more conservative in their interpretation of the Constitution, and the 3 at the bottom would be a little bit more open and progressive in their interpretation of constitutional issues. But back to this slide, we now have 13 federal circuit courts, or courts of intermediate appeal, and 94 federal district courts, which are the federal courts of original jurisdiction. Notice that the 13 circuit courts have geographic jurisdiction over more than one state, often several states. South Carolina is in the 4th federal circuit, along with North Carolina, Virginia, West Virginia, and I think it includes Maryland. Yeah, there's a little area pointing at Maryland. Don't get confused. Below Maryland, it says DC and Fed. The DC has its own circuit court, the district court for the the circuit court for the District of Columbia. That's its own little circuit. It's not in the 4th circuit. And then there's the federal circuit. It's its own little circuit court system. It's not in the 4th circuit. The 4th circuit is only going to include states like Maryland, West Virginia, Virginia, and North and South Carolina. A federal district court's jurisdiction is not as easy to see on this slide, but it often matches the political borders of a specific state. Some of the more populated states, like if you look at California, you see that there's more than one district court, federal district court in California. And you can see the little thin lines that are inside the state of California designating the different district courts and where their geographic jurisdiction there. It's often divided up based on population, as you might have guessed. So here's a little graphic display of our federal court structure. And this is not typical. This is just how it is structured. It's all exactly the same way across the US. So down at, well, I'm actually going to start with district courts. They're kind of lower middle there, US district courts. So those 94 courts, district courts, are the courts of original jurisdiction where federal trials happen, where federal cases begin. There is often a jury. If you recall the language from the 7th Amendment, it gives litigants the right to a jury in most federal cases. Evidence will be presented to the jury and witnesses will testify. An evidentiary record is formed for the case. Then the judge or jury will decide the case and the outcome will bind the litigants to the case. Now, down here, there are lower courts beneath the U.S. district courts. They're known as magistrate courts. These were created because of the size of the docket. There was just too much going on in the district court. So Congress created these lower magistrate courts to handle some of those cases. So those are U.S. magistrate courts will have limited jurisdiction. Okay, so it would be covering. There may be like a bankruptcy court. They would just hear bankruptcy cases and so forth. And if there's a dissatisfied litigant in the magistrate court, once the case is over, they appeal to the U.S. district court. So it's almost like they're going to hear it all over again. So the district courts may hear appeals from the lower magistrate courts, and it's like the case is kind of starting all over again. So the district courts can still hear evidence that was also presented to the magistrate court. It's called trial de novo. I think that's in your textbook. So from the district court, then we go up on appeal to the U.S. circuit courts. There is a right of appeal from decisions of the U.S. district courts. And the U.S. circuit court that it is appealed to would be the one that encompasses the district court. So it's the geographic jurisdiction again that we saw here. So like the Fourth Circuit Court of Appeals would hear appeals from the District Court of South Carolina or the District Court of Western North Carolina, or so on and so forth. They would all the district cases would go up from the district courts up to the Fourth Circuit, all within that geographic jurisdiction. So at the circuit court level, there's a panel of judges who will hear the appeal by receiving briefs that address the legal error committed at the lower district court level. No new evidence is received in the circuit courts, and the circuit court's decision will bind all the district courts within that circuit. Now, one circuit court's decision can be persuasive to another circuit court, like a decision of the Fourth Circuit can be persuasive upon the Fifth Circuit or the Sixth Circuit, but it will not bind the other circuits. It's only binding on the courts within a single circuit. Next, the next level, as far as hierarchical jurisdiction goes, is the U.S. Supreme Court. The Supreme Court will not hear appeals of right, except in very limited situations. The U.S. Constitution sets or gives some original jurisdiction to the U.S. Supreme Court, but it's very, very narrow. So mostly, probably 99% of the time, the U.S. Supreme Court will only hear cases that it wants to hear. The parties in the circuit court who are upset with the decision of the circuit court may file a petition for writ of certiorari, and the Supreme Court has the discretion to hear it or not. So for most cases, then, the circuit court is the court of last resort and cases stop there. But sometimes, such as where there's a divergence among the various circuit courts in the interpretation of the Constitution or some federal law, the U.S. Supreme Court may grant a petition and receive briefs from the litigants. And as you know, a decision of the U.S. Supreme Court is where the buck stops. Cases go no further. The precedent is set and it is binding over all federal courts in the United States. And keep in mind that when the U.S. Supreme Court denies a petition for writ of certiorari, it is not an approval or a disapproval of what the circuit court did. It has no precedential value at all. It's not the Supreme Court commenting and saying, no, we're not going to hear the case because we think the circuit court got it right. No, that's not what's happening. It is simply the court saying, we don't think that this case needs to be heard by us. That's all it is. So don't read too much into a denial of certification or certiorari. So now that you see the geographical and hierarchical jurisdiction of the federal courts, let's consider the subject matter jurisdiction of federal courts. Since our federal government is a limited government, the federal courts, by their nature, are courts of limited subject matter jurisdiction. A federal court can hear a case only under two circumstances. The first is when the subject matter of the lawsuit involves a matter of federal legislation, a federal crime, or involves the interpretation of the U.S. Constitution. Those are known as cases that arise under federal law. So if you're looking at Section 2 of Article 3, it says the judicial power shall extend to all cases in law and equity arising under this Constitution or the laws of the United States. So the federal laws, whether they're civil laws or criminal laws, the federal laws or Constitution, those are cases arising under federal law, which are within the subject matter jurisdiction of the federal courts. Now, the second time a federal court will have subject matter jurisdiction is when there's a controversy between citizens of different states. That means they have what's known as diversity of citizenship. So a party from one state is suing a party from a different state. And in addition to that diversity of citizenship, their dispute has to involve a good bit of money. So the federal court's not going to hear a little small claims case between someone who lives in South Carolina and someone who lives in Georgia. That's not what this is about. There's got to be a lot at stake, and the parties have to be from different states. And the reason for this, I'll elaborate just a little bit here because I practice a lot in this area. The reason for this is to avoid something that is known as home cooking. Or home cooking, if you want to use the slang there. It's silly. What happens oftentimes, like most litigation, as you might imagine, it involves personal injury. So someone is, I don't know, they walk into Walmart or something, and they get hurt. You know, maybe a rack is loaded too high and it falls on them and crushes them and breaks bones or something, but they get injured in Walmart. Okay. And so this is like the little average guy who goes into big giant Walmart and gets hurt, and he gets, I don't know, George Sink, injury lawyer, like call all nines, right? And he files his claim, and George Sink goes out and files a lawsuit. Well, you know, he may be really inclined to file his case in Greenwood, South Carolina, because who are the jurors going to be? They're going to be Greenwoodians. They're going to be able to relate really well with the little guy from Greenwood who got crushed by a big old, you know, stacks of, I don't know, nails or something. And then the other party is big, bad corporate Walmart. And so you can see how a jury that's made up of average Greenwoodians might have a beef with Walmart and think that they can get back at Walmart and, you know, return this huge billion-dollar verdict. So that's called home cooking. They're going to get this big corporate client or big corporate company and make them pay. Right? That's the mindset that they're looking at in this type of subject matter jurisdiction. So in those instances, the court is going to have to determine whether this other party, like this big corporation, is a citizen of the state where the injury happened. And Walmart probably would be counted that way. I'm not sure. It would require some analysis. But when they're not, like if it's some company that only has, this one little branch in Greenwood, but is basically a citizen of, I don't know, Montana or somewhere way off, they'll remove that case from the state court and send it to the federal court, with the idea being that this out-of-state party won't be home cooked if the case is heard in federal court as opposed to a local state court. That's just a little rambling diversion. I just wanted you to understand why we have this second basis for subject matter jurisdiction in federal courts. So now that you see how our courts are organized, let's look at the people who do the work within them. The textbook refers to them as court actors. And in a way, a trial really is kind of like a play. Judges are sort of like the directors of the play. They have the authority to tell the other actors what to do. They direct the flow of the case, applying court rules of procedure. They are meant to be impartial referees, making sure that the parties and their attorneys play fair and abide by the rules, including the due process procedures required by the Constitution. Judges will decide the legal issues in the case, the points of law that may affect the outcome of the case regardless of the facts. They decide what evidence will be admitted to the record or presented to the jury, so a judge will then filter the evidence. And at the end of the trial, a judge is going to instruct the jury on what the law is. So that's what the judges do. Now, how do they get their job? Well, that is known as the judicial selection process. Judges are, of course, lawyers first. They go to law school, take the bar, and practice law to gain experience. But judges are often scholars, too. They write about complex legal issues, and they often teach in law schools. So they demonstrate a measure of legal expertise beyond just the basic practice of law. And they do so until they get the attention of political leaders and enter the pool of judicial appointees or candidates. Now, at the federal level, all judges are appointed by the president and approved by a majority of the Senate. And that process is set by the U.S. Constitution in Article 3. And as I read, they are appointed for life or good behavior. But at the state level, judges can be selected in a variety of ways, through partisan or nonpartisan elections, appointment by the governor, or through some merit-based system. And states vary a good bit in this process. There are pros and cons to each way. And if you look in the book, I've forgotten what page it's on, I believe there's a table or a figure or something that shows each state and what their judicial selection process is. And you can look and see the variety. I mean, it goes on for a while. But let's look at the pros and cons then for the different ways a judge can be selected. And I'm focusing mostly on just appointment versus election. So electing judges can be a good thing. So as you might expect, though, if a judge is going to go through a partisan election, he or she usually has to choose a political party and engender the favor of wealthy donors or special interests to his or her campaign and engender the favor of the public. So the average public often is not educated in the law, and they cannot assess the legal skill of the judge. The public is going to vote for whomever they like, not necessarily a legal expert capable of the impartial interpretation and application of law. So by electing judges, we may set them up to be accountable not to the law, but instead to the whims of their constituents or to the whims or special interests. But electing judges can be good because it is a populist ideal. The law should reflect the values of the community, and electing a judge will hold them accountable for that. Now, appointment. Appointment is also somewhat problematic because it removes that accountability. Once appointed, the judge can act without concern for their own job stability. And that fosters impartiality, which is good. It allows the judge to just focus on the law and apply the law without bias or partiality. But it also allows the judge to lose touch with the practical consequences of his or her decisions. And we know when we talked about legal realism that subjective beliefs inevitably affect a judge's decision. And his decision or her decision, particularly when it comes to constitutional issues, will directly affect public policy. You've probably heard complaints in the media about liberal justices who are ruining the country, or conservative justices who are closing their eyes to reality and not moving with the times. Okay, that's just a reflection of legal realism, just knowing, yeah, they're legal experts, they know the law, they're going to apply the law, but they can't help but be human. No matter how a judge gets the job, they're still human. They're not perfect. So there's pros and cons, you see, for electing versus appointing, and there's no perfect process. There's no perfect judge, perfect system. Just have to remember they're all. And you can see in the book, there's some discussion about the merit system. I believe in South Carolina, the judicial selection process is more of a merit-based system, or some sort of combination of appointment and election. But you can look into that on your own. The next court actor is the attorney. And attorneys are very much like actors in a play. An attorney's job is to speak on behalf of their client. So it's almost like the client writes the script, gives the story, and then it's the attorney's job to speak the lines, to speak on behalf of their client and persuade the judge or jury to decide an issue in their client's favor. So attorneys are advocates. They also, though, must advise their clients on the legal consequences of choices. They are advisors and counselors. And note that in criminal courts, the attorneys who prosecute the crimes, they do not represent victims. They represent the people. So in federal court, the federal prosecutors represent the people of the United States. And in state courts, the state prosecutor represents the state, like the state of South Carolina, or in a more local situation, you have an attorney for the county of Greenwood, the county solicitor, who represents the county, the people of Greenwood County, in prosecuting the crime. They don't represent the victim. They are interested in they're looking out for the interest of the victim, because the victim is a member of the public, a member of the people, but they are not the direct client. The government, whether it's federal or state, the government is the client, or the people are the clients. Defense attorneys, though, they represent just the single individual, the defendant. And so their job is to protect the due process rights of the defendant, even if that defendant is factually guilty and they know it. The defense attorney's job is to see that due process is protected. So how do they get their job? Attorneys become advocates and advisors by first completing law school. Once they graduate, an attorney must take and pass the bar examination of the state where they're going to practice. And a bar examination is a very, very comprehensive, long, very long, days long exam. And once they pass that exam, they become a member of the State Bar Association. And in order to maintain that membership, they must complete continuing education courses, which, like, I think in Alabama, it's 12. Yeah. In Alabama, it's 12 hours per year of continuing ed work. And you also have to abide by very strict ethical requirements. And when you do those two things, you maintain your status as a member in good standing of your state bar association, and you're permitted to practice law in any court within the state. And you can be disbarred if you do not behave yourself, or if you do not get your continuing ed work done. You can be disbarred and lose your right to practice law in that state. And all of this is policed by the Bar Association. Once you are practicing, though, you can practice in a lot of different areas of law. I've listed just a few here. My area of practice was civil litigation, which is in that list there. So when I was working regularly in law, I would represent parties who were suing each other, right? So one party's mad at another party, whether it's usually, for me, it was involving money. And so I would represent one of those parties in the battle to see who gets the money. That's civil litigation. There are all different kinds of specializations that you can have. And most attorneys are very specialized, except in little small areas. Like most lawyers in Greenwood, they practice what they call threshold law. Whatever kind of case crosses the threshold of their firm is the kind of law they practice. But when you get into bigger cities and such, you can specialize a little bit more and focus your attention on those subjects. All right, the last court actor is the jury. And the jury is kind of like the audience. They listen to the evidence and the testimony. They find the facts, which means they get to decide whom or what to believe about the evidence. A judge is going to determine, right, the judge is the filter. So the judge filters the evidence and decides whether the evidence can even be presented to the jury. But the judge cannot decide what evidence or testimony is ultimately believed or found to be true. That is a matter left entirely to the jury. The judge is determining, I'm just kind of repeating myself, the judge is determining whether the evidence is relevant, reliable, and authentic. But the jury decides whether it is true and what the consequence should be. So the jury is known as the trier of fact. At the end of the trial, the judge will tell the jury what the law is. The jury then applies the law to the facts and decides the case. People are chosen to serve on a jury through a process that goes like this. Potential jurors are called to appear. Usually the call comes in the mail, and they're identified by their voter registration or driver's license records. So you get a little letter in the mail from the court saying you've been selected to serve on a jury, and here's when you have to show up, whether you like it or not. So you show up, and you are in what's called a pool or a venire. You're in a venire. I think that's Latin for something. Then once you're in that pool, you'll be interviewed by the judge and attorneys through a process known as voir dire. During this question and answer process, the judge is supposed to impanel a jury of the defendant's peers. That's a constitutional requirement. But all it means is that the jury has to come from the defendant's community. It doesn't have to look like them. It doesn't have to look like the defendant. It just has to be a member of the defendant's community. The voir dire process is supposed to reveal any partiality. So also in the Constitution is the right to have an impartial jury. But all that means is that the jurors have not yet formed an opinion on the outcome of the case. It doesn't mean that they've never heard of the case or never heard of the parties. They're simply open-minded about the case and able to consider both sides' evidence impartially. So throughout this voir dire process, attorneys are listening, and they can strike out jurors they don't want to be impaneled. They're allowed a certain number of peremptory strikes where they don't have to give a reason why they're knocking them out of the pool. But after that number is reached, the attorney must state a reason or cause to eliminate a potential juror from the pool. And once that voir dire process is over, the judge will impanel the jury that will ultimately hear the case. Note that sometimes the voir dire process becomes suspicious, and a party can assert a challenge to his or her opponent's choice to strike a potential juror based upon the race or ethnicity of the juror. This is known as a Batson challenge. Batson is the name of a lawsuit or a case that went all the way to the Supreme Court about the impact of racism in the jury selection process. And it created this precedent for parties to challenge a strike of a jury, saying that it was based on some sort of racial or ethnic bias. And that can be a right that can allow a person to completely overturn a verdict because of the racial bias that was involved in the process of impaneling the jury. So it's known as a Batson challenge. So now we've talked about the organization of the court system and the people who work in it. And our last topic is judicial process. We're going to go over the steps of a typical criminal trial. I want you to know, though, if you find this interesting, Lander offers a course that covers judicial process in much greater detail. So if you really enjoy this part, you'll want to take that course. What I'm going to do is just offer an overview. It's nowhere near as detailed as you might get in that other class. And also, when I'm doing this overview, I want you to know that there is a lot of variation state to state in how criminal trials will progress. But the U.S. Constitution sets up, just by virtue of the due process protections, will indirectly set up a certain order in which steps must go and certain steps that actually they must happen because of due process guarantees. And I'm going to highlight those as I cover the steps. So a criminal case begins with some type of a complaint. The complaint can come from a private citizen or a police officer, and it has to be backed up by testimony given under oath, such as an affidavit. There must be some initial evidence that a crime has been committed by a specific person. And the amount of evidence that must exist initially is probable cause. And we'll define probable cause more carefully in Chapter 6, but for now, just know that probable cause must exist before a criminal case against a specific defendant can be commenced. Another way to begin a case is when a prosecutor, again, based upon probable cause, files a document called an information, which identifies the charges against a defendant. In a federal case, the U.S. Constitution requires a grand jury indictment to commence a case. A grand jury is similar to a trial jury, but they're not exactly the same. A grand jury is usually larger, more than 12, and they're only going to hear evidence from the prosecutor. It's not an adversarial hearing. It's very one-sided. The defendant usually doesn't even know that a grand jury has been impaneled. So the grand jury is going to hear the prosecution's evidence and determine whether there is cause to prosecute a specific defendant with a crime. And if the grand jury finds that, it will issue an indictment that identifies the charges against the defendant. Grand juries are required by some states, but not all. So the U.S. Constitution requires a grand jury for all federal cases. But when it comes to state court systems, you have to look at the specific state, and not all states require grand juries. So the grand jury is sort of like a check on the power of the prosecutor or the power of the court system. They want to, the idea is the grand jury is going to sort of protect the public from prosecutorial misconduct or abuse of power. So the grand jury is sort of a check on that power that a state government has to prosecute a defendant. So you can have a complaint, an information, or a grand jury indictment, but in either way, you're going to have a charging document, something that identifies the charges against the defendant very clearly and is backed up by probable cause. So that commences the case. Next comes booking, which is when a defendant and the information about the case goes into some sort of administrative record. And you probably are familiar. This is where you get your mugshot and you're fingerprinted. So at some point very soon after booking or an arrest, a defendant has a right to appear before a judge and be informed of the charges against them. That is a constitutional requirement, that a defendant be informed of the charges against them. So the defendant will make an initial appearance and be informed of those charges and his rights, and bail may be set at that point. This must happen very soon after an arrest, and it's generally within 48 hours. Now, there are other instances in judicial process where a defendant will appear before a judge. There's an arraignment and there's a preliminary hearing. And I'm going to talk now about what an arraignment is. An arraignment is sort of like the initial appearance, but it's going to come a little bit later in the process, after the defendant has an opportunity to have an attorney appointed for them and be advised by their attorney. And it is in the arraignment where the defendant will first enter a plea. So the plea could be guilty, not guilty, and there may be one other, some sort of allegation of mental disease or defect could be asserted. But a plea is entered during the arraignment after the defendant's had an opportunity to have counsel appointed for them or hired by them. to represent their interests. So once there's been an initial appearance, the discovery or motion practice can begin. And this is just the evidence collection process or evidence sharing time. The prosecution must disclose all of its evidence to the defendant. That's a constitutional requirement. It's part of being informed of the charges against you and being able to defend yourself against them. So they discover one another's evidence. And also during this time, parties can file motions with the judge, legal motions, making some sort of point of law or asking the judge to do something with the case. It's usually like a motion to suppress evidence or a motion for a change of venue. Motions tend to be heard very shortly before trial begins, but they're going to settle up some of their differences on the evidence before the trial begins. And it's evidence they've discovered during the discovery process. And also at some point before trial, there could be a preliminary hearing. And so let me explain what a preliminary hearing is. It is different than a trial, and it's also different than a grand jury hearing. A preliminary hearing is held before a judge, no jury, just the judge. And it is adversarial. The defendant knows about the preliminary hearing and has his attorney present at the hearing. The defendant has the opportunity to present their own evidence, to cross-examine the witnesses, but they aren't obligated. The defendant is never obligated to do that. They can just sit back and listen and let the judge decide whether there is cause to go forward. If the judge finds that there is probable cause to try the defendant, then the defendant will be bound over for trial. The prosecution, I'm pretty sure you guys know this, but just to make sure, the prosecution has the burden of proof and persuasion. So the prosecutor has to, and this is because all defendants are presumed innocent. I'm sure you've heard that. Criminal defendants are presumed innocent. They can't go into a trial where the jury assumes they're guilty and they're just trying to get out of it. It's not like that. The prosecutor has to present evidence and persuade the jury that the defendant is guilty beyond a reasonable doubt. So the prosecutor has the burden of proof, or the government has the burden of proof and the burden of persuasion. The defendant has neither of those unless they want to assert an affirmative defense, such as mental illness. At the preliminary hearing, the defendant has a right to counsel. That's a constitutional guarantee. The preliminary hearing is a critical stage in the prosecution, and the defendant has a constitutional right to have counsel present representing them in the preliminary hearing. Next comes the jury selection process, the voir dire, which I've already gone over, so I won't do it again. I just want you to keep in mind, when it comes to jury selection, you're probably jumping to the number 12 in your mind. Like there's always 12 jurors on a jury. That's not constitutionally required. That's just a matter of tradition and practice. It's the most common number, but it's not, 12 is not the magic number required by the Constitution. It's just a tradition. All right, so now we've gone through all the hearing. The defendant is informed of the charges against them. They have an attorney that's been advising them. They've exchanged the evidence, taken depositions, filed their motions. Jury's now impaneled. Trial is beginning now. The trial, if we're going to keep with our analogy, the trial is the play. So the play is going on, right? And there are several steps in the play, or you might call them like the scenes or the acts of the play. It starts out with opening statements, not opening arguments, opening statements. Both sides have a right to state what the evidence will show, but they are not supposed to argue the evidence yet. And the defendant isn't even obligated to make an opening statement. They may, and they often do, but they aren't required to. And the whole point is just to sort of give the jury an understanding of what they're going to hear, almost like a summary of what they're going to hear. It is not supposed to be argumentative. It's supposed to be a very straightforward statement of the facts. Then the prosecution gets to start. Remember, the prosecution has the burden of proof and persuasion beyond a reasonable doubt. So they start calling their witnesses and presenting their evidence to the court. The judge is listening, filtering that evidence, and making sure the attorneys behave themselves. Prosecution will then rest, and the defendant will have the opportunity to cross-examine. Well, the defense attorney would cross-examine witnesses during the prosecutor's case. And then once the prosecution rests, the defendant can present its own case, call its own witnesses. So in the Constitution, the defendant has the right to confront the witnesses against them by cross-examining the prosecution's witnesses, but the defendant also has a right to compel witnesses to testify on their behalf. They can subpoena a witness to testify. Now, the defendant, again, has no burden of proof unless they're presenting an affirmative defense. We'll talk more about affirmative defenses when we get to Chapter 5. Just keep in mind that they do not have a burden of proof or persuasion unless they're presenting an affirmative defense. So a defense attorney can sit and just listen to the prosecutor's evidence and poke holes in it. So the defense attorney is trying to create reasonable doubt in the mind of the jury. They're poking holes in the prosecutor's case, showing that there is reasonable doubt and therefore their client should not be found guilty. So after the defendant rests, there is a time for a rebuttal where both sides can come back and introduce more evidence and witnesses to rebut something that was previously stated or presented to the jury. Then each side has a closing argument, and here is where the arguments come in. The prosecutor again goes first because the prosecutor has the burden of proof and persuasion, and they will argue the heck out of the evidence in the law. And then the defendant will give his or her closing argument in the same manner. Then the judge will instruct the jury on what the law is, and the jury will go. Sometimes they're sequestered, isolated, quarantined, if you will, and sometimes they're not, but they will deliberate and come to a verdict. Note that there is no constitutional requirement for a unanimous verdict, even in criminal cases, unless there's only 6 jurors. And in those instances, the Supreme Court has said the verdict must be unanimous. And sometimes a jury simply can't come to a conclusion. And so the judge, this is called a hung jury. And in that case, the judge will declare a mistrial. And the defendant can be retried before a different jury. Keep in mind, though, that a mistrial has no consequence as far as double jeopardy goes. It is not a final adjudication of guilt or innocence. And that's why the defendant can be retried after there's been a mistrial or hung jury. So after the trial ends, if the defendant is found guilty, the case will enter the sentencing phase. In sentencing, sometimes additional evidence is gathered and presented that might affect the type of punishment or the severity of the punishment that the defendant will receive. Many states have sentencing guidelines that provide for the length or type of punishment that a defendant can receive for a particular crime. And the point of those guidelines is really to help maintain some uniformity in sentencing, eliminate some of the bias in sentencing, and whether it's effective or not, I'll leave for you to decide. But no, that's the point. And if you remember, we were talking about Aristotle's definition of justice, and we were pointing out how it's treating equals equally and unequals unequally according to relevant differences. So those relevant differences when it comes to sentencing are usually outlined in the sentencing guidelines and could be such things as whether the defendant is a repeat offender, whether the defendant is very, very poor, what kind of life they've had, whether they've been the subject of abuse or some other factor that would justify the differential aspect in sentencing. And finally, if the defendant has been found guilty, the defendant can file an appeal of the verdict. It can be a direct appeal within a certain time period, or outside that time period, a defendant can file a petition for writ of habeas corpus. And that's a little different than an appeal of right. A writ of habeas corpus is a challenge to the right of the state to keep him in custody. And it can happen right up to the end. You might be more familiar with it in terms of when a defendant has been sentenced to death, and you might hear or see movies about, these last minute appeals where they're trying to establish that they should never have been held in custody in the first place. That's known as a habeas corpus appeal. Anyway, so that concludes our overview of judicial process, and that concludes my lecture on Chapter 4. It's a very broad overview, and as I'm sure you noticed, there are a lot of variations state to state. What I want you to keep in mind and focus on is how the Constitution then will affect the order and sequence of these steps and place obstacles to an arrest and conviction.